Thank you, Mr. Chairman. Let me ask to start off with Mr. Brobeck. Over the weeks, we have been hearing an enormous amount of testimony from the industry and today from the Secretary of Treasury that Western civilization would collapse as we know it if states were given the full power to protect consumers in this area. Do you think civilization would collapse, or do you think maybe consumers might get some benefit if we had attorneys general throughout this country and legislatures and governors who wanted to stand up and pass a stronger consumer protection law than Congress is apt to protect? Can you comment on that, please?
Mr. Congressman, I don't even think a small part of civilization would collapse. After all, before 1996, a number of states passed from some very strong measures that were grandfathered into the 96 law, and the sky did not fall. The industry adapted. In fact, they ought to be better able to adapt now because of technological improvements. I see this in the whole area of provision of social services. Because of computers, we have dramatically lower cost. I can't imagine that those cost savings are not available to the industry as well. And there's going to be a small cost here, some inefficiency, but I would urge this committee to ask the industry, whenever they allege that the sky is going to fall on them, that they document carefully the costs of interventions by the states that they've already taken, that are in force right now, and that they then compare those costs with the benefits that have accrued to consumers as a result of those interventions.
Now, what am I missing, Mr. Brobeck, when I think that if there are particular problems in a state, whether it's Alabama or Vermont or California, that the legislatures and the attorney generals of those states might be able to respond more effectively and quicker at the statewide level than waiting for the United States Congress to move? What am I missing in terms of the needs of consumers?
Well, we don't think you're missing anything. In fact, our federal system is wonderful because the states, it gives the states an ability to respond more quickly, which they often do because there are 50 of them rather than just one U.S. Congress, to respond to problems that arise. Sometimes those problems are local or regional, so there's more interest in that state in responding to a problem than there is, say, in Washington. But I mean, where is the harm? We've seen the macroeconomic analysis that ascribes the growth in our economy in the 1990s to the credit reporting system. I would argue that there are many other far more important factors. One could even perversely argue that the credit reporting system is somehow related to the rise in consumer bankruptcies. Because after all, if consumers' scores are inaccurately high, then they are more likely to take on credit that will lead to default. If they are inaccurately low, the creditors will turn around and charge them higher rates. In both cases, that will tend to drive borrowers into insolvency.
Let me take that statement and lead to a second question. And Mr. Spriggs, Dr. Spriggs, or anyone else can comment on it, but let me address to Mr. Brobeck again. I have been concerned about a scam which I call switch and bait and switch, by which companies, credit card companies, say, we're going to give you, Mr. Brobeck, 3% for a year. You pay every month faithfully what you owe the credit card company, and lo and behold, after 4 months of paying on time, suddenly your interest rates have gone from the 3% they promised to 25%. And the reason that they will explain to you is that you borrowed more money because your wife was ill and so forth and so on. What do you think about that type of action, and what should Congress do to address it?
Well, we think that's unfair. I mean, what is driving that is that in a certain sense, credit card markets have become more competitive, and the so-called traditional rates, they're basically, tiered rates, the promotional rates being under 5% typically, traditional rates. Traditionally were 18%, but now they're as low as 10 or 11%, and then you have the penalty rates. Well, competition in middle markets and upper markets basically drove the traditional rates down. That squeezed the margins of the creditors. They looked for other income opportunities, and what they did is they raised the fees and they created this penalty rate category, and now what they're doing is some of them are figuring out clever ways to move people from the traditional rates into the penalty rates. And unfortunately, they're using credit scores as an excuse to do that, or other material in credit records.
Right. Dr. Spriggs, do you want to comment on that?
Well, I did, because it gets right back to the issue of the credit scores, because that drives the market so much more than just what comes out of the credit bureau. And that intermediary effect is what gets you out of that, allows them their out. Because probably that fine print that you didn't observe, it's not as unilateral as it may appear, is something to deal with your credit standing. And the moment that extra loan came, your score changed. So they may not be making as unilateral a switch as it at first appears. That issue is important because we don't know what's in the models. We don't know, maybe after you looked at the models, you might say, I see their point, it looks valid. But you may also look at their models and say, well, if you modeled it differently, and here's a different scoring company that models it differently, they wouldn't have scored me that way. Why does this model say that that's bad? We could have that exchange, but we can't have that now. And so we need to get them out of that loophole by making this more transparent.
Does anybody have an idea? I'm kind of curious that when we understand that about 5 billion applications, credit card applications, are sent out a year, which is an astronomical number, I would be curious to know if we have some figures on what percentage of people who sign up for one promotion or another end up paying higher rates than was on the original promotional application. Does anyone have a guess on that? What percentage? I mean, if they come to me and they say, Mr. Sanders, you're going to have 3% for a year, and they raise me to 20%, what percentage of the American people are in that box?
You know, Congressman, I don't know, but yeah, I just want to mention that I think there's a law on the books today that squarely addresses the issue that you raise in the context of the potentially bait and switch scenario. The Truth in Lending Act requires, pursuant to a recent Federal Reserve Board amendment to Regulation Z, that any credit card account that offers an introductory rate, that introductory rate has to be disclosed on those Schumer box disclosures, and the penalty rate has to be disclosed as well. Under those, and the circumstances under which the penalty rate may be imposed must be disclosed also. Now,
is it, excuse me, let me just ask you for clarification. Is a penalty rate, if I borrow money from another source, is that considered now a penalty?
Well, actually, I think what you're referring to is risk-based pricing.
Yes.
And what can happen in a risk-based pricing scenario is a creditor obviously has one view of a particular consumer's experience with that creditor. What it will do in some circumstances is go out to a consumer report to see if there's a more complete picture that gives a better understanding of that consumer's risk. In some cases, they may find that the consumer's defaulted on several other loans, therefore presents higher risk, and the creditor at that point has a couple of choices. It can either allow the other consumers in the portfolio to pay for that consumer's risk, or can price that consumer's product so that that consumer pays for the risk that consumer presents.
Bottom line, let me ask you this, and then I'll give back the mic here, is that if I signed up with your credit card company and I faithfully pay you every month what I owe you, do you believe you have the right to double or triple my interest rates, even though I've never missed the payment with your company?
Well, I can't get into the doubling or tripling.
That is what happens.
But I am aware that what will happen is that when that introductory offer is made, what will be disclosed to the consumer is the fact that this rate, this introductory rate, may go away under certain circumstances, and under the Truth in Lending Act, the creditor's got to describe those circumstances before the consumer even applies for the account.
Yeah, but sometimes that language is written in very, very tiny writing, is it not?
Well, actually, these disclosures under that recent Federal Reserve Board amendment I mentioned have to be in a certain type size.
Thank you, Mr. Chairman.
Mr. Sanders, if I could just
Sure.
respond to one comment that was made about the credit reporting industry as though it was somehow responsible for bankruptcies in this country. And I just can't leave the record void on that, that literally 2 billion consumer reports are sold every year in this country. 16 million consumers look at their files every year in this country. Less than half those consumers ever even call the credit bureau back, although they have toll-free numbers and access to live personnel. And for us to be left with the impression here on this hearing record that somehow whole-cloth credit reporting systems are vastly inaccurate and somehow contributing to bankruptcy is just a falsehood.
I think Mr. Brubeck was attempting to do what some in industry have done and suggest that if we give the states the right to protect consumers, somehow this will be causing devastating. He was being a bit hyperbolic, I guess is the word, right?
Well, actually,
Okay.
I'm not going to. I was trying to analyze the last 7 or 8 years and suggesting that was as plausible,
As
one
the
plausible explanation for the rise in consumer bankruptcies.
Okay.
One of many.
Okay. Thank you. Thank you very much.